Factors indicating recidivism is less likely as the defendant has no prior adult criminal convictions. Prison is mandatory, obviously, on count 2, the murder, with the specification, so the court finds prison is consistent with the purposes and principles of felony sentencing. The defendant is not amenable to available community control sanctions. This was an interesting case because in this case, this jury had everything possible before it to render a just verdict. The Willoughby Police Department and the other law enforcement agencies that assisted in this investigation scoured every potential source of evidence and followed every lead to ensure that the state, defense, and jury had all of the evidence. That included all inculpatory and exculpatory evidence. As far as the murder itself, the jurors not only had a video from the alley, but video pretty much from the time you arrived in Willoughby until the time you left. The video from the alley did not contain any audio. You testified and had the opportunity to narrate the events that unfolded in that alley. You made choices. You are being sentenced today due to the choices that you made. Those choices included taking a 17-year-old to a bar and the choice to take a loaded firearm into that bar. That choice is the only reason a firearm was involved in anything that took place in that alley. And the choice to drink in the bar with the 17-year-old, and the choice you made in the 30 seconds between shots. And that choice was to execute a defenseless 17-year-old. And make no mistake, that is what happened here, an execution. Point blank to the back of the head. Followed by the choice to throw the firearm into the Grand River, and finally the choice to flee the jurisdiction. These choices have led to the sentence I'm going to impose upon you in this case. The sentence of the court is the defendant is to serve a stated prison term of 3 years on the gun specification to count 2, and a stated prison term of 1 year on the gun specification to count 3, which are to be served consecutive to each other. I believe that is mandatory pursuant to revised code section 2929.14B1G. You're also to serve a stated prison term of 36 months on count 1, an indefinite prison term of 15 years to life on count 2, and a stated prison term of 36 months on count 3. Those sentences are all to be served consecutive to one another, with credit for 334 days already served and served at the Lorraine Correctional Institution. You're to forfeit the firearm involved to the Willoughby Police Department. Consecutive sentences are necessary to protect the public from future crime and to punish this offender. They are not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of this offender's conduct. I have considered your present and future ability to pay financial sanctions, and in accordance with the revised code section 2929.18, you're paying any costs and fees associated with this case. There was no request for restitution in this matter. As to counts 1 and 3, post-release control is part of this sentence. You may be on post-release control for up to 2 years as determined by the adult parole authority. If they place you on post-release control and you violate any of the conditions of your post-release control, the adult parole authority may impose more restricted post-release control sanctions, or they can return you to prison for up to 9 months for each violation, up to a maximum of 50% of your stated prison term. For violation of post-release controls for committing a new felony offense, you may be prosecuted for that new offense. In the court in which you're being prosecuted for the new felony, that judge may impose an additional consecutive prison sentence for the post-release control violation. The maximum prison term for the post-release control violation shall be the greater of 12 months, or the period of post-release control for the earlier felony minus any time you have spent under post-release control for that earlier felony. You have a right to appeal. If you are unable to pay the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed without cost. If you're unable to pay the cost of documents necessary to an appeal, including a transcript of the trial, the documents and transcripts will be provided without cost, and you do have the right to have notice of appeal timely filed on your behalf. In discussions with Mr. Blake, he is asking the court to appoint an attorney. It's my understanding he did fill out the appropriate paperwork, so the court will appoint the Lake County Public Defender to prosecute the appeal on your behalf. The court does disapprove of any placement in shop incarceration or intensive program prison. Bond, if any, is released. Is there anything further from the state?
No.
From the defense?
There.
To Isaac's family, I'm very sorry for your loss.